Federal High Court sitting in Abuja has delivered a judgment that brings finality to the case filed by the Action People's Party against Rivers State House of Assembly, the Independent National Electoral Commission, and the People's Democratic Party. Recall that the APP had sought a review of earlier court rulings concerning the status and legitimacy of the Rivers State House of Assembly and the electoral processes overseen by INEC and the PDP. The court, however, rejected the APP's request, affirming that it had no jurisdiction to act as an appellate body over a judgment already rendered by another competent court. In its ruling, the judge stated that this court cannot in no doubt sit on appeal in a declaration of its brother judgment, underscoring that the legal principles governing the matter were already settled by the previous court's decision. With this judgment, the long-standing legal tussle involving the Rivers State House of Assembly has been put to rest, reinforcing the rule of law and the independence of the judiciary. What do you have to say to this story, Ifeanyi Chukwu? Do you think it will actually bring all the brouhaha to rest in Rivers State?
It has already buried the political tussle, especially as it concerns the soul of Rivers State House of Assembly. I never knew there is already this litigation by APP, and if one may ask, what is in it for APP? Why is APP becoming an interested party, and who wants to cry more than the bereaved? Because hitherto to this particular judgment, I never knew APP. We had that of Boot Party. We know that of the other faction of APC, and the PDP loyal to the governor of Rivers State, Simon Fubara. But I was very oblivious of this case until the judgment yesterday, as APP being an interested party. And one may ask, what was the input, or what was the in-route of APP during the last general elections? We never heard anything about APP. And if APP had filed a case like this, you will recall, it will call to mind that the insinuations and what you are seeing in Rivers State now, the local government election that is coming up, being that the state actors, the present political state actors, when I mean actors, the present political administration in Rivers State are fraternizing with APP. It is not to be, it is a thing of no surprise to me, because since 2 weeks ago, I've been so inundated with a lot of questions by friends and colleagues, why the insinuation rages about the interests of the governor in APP. So if they had filed a case, so their marriage allegedly did not start today. What we are seeing is the consummation when it comes to what is going to play out in Rivers State local government elections. And as we have seen, the PDP is not going to be in the ballot, but the governor and the House of Assembly members, the Okojumbo-led faction of the Assembly members are of PDP. So, and again, the Justice Peter Lefu, reminded those that went to court that this, what they are coming to ask for has been overtaken by events. If I may recall, the judgment of Omotosho on the 22nd of January have not been vacated. It has not been appealed.
It can't be. The question is, when you bring up the judgment of Justice Omotosho, because ordinarily what APP would have done would have been to vacate that judgment, to appeal that judgment, to seek for its vacation.
Yes.
However, in the grand scheme of things, the window for vacating that judgment or for appealing it has elapsed.
Of course.
So the judgment cannot be vacated. That is why they had to
institute a new
suit. Right.
But instituting a new suit, they have. I wondered why Justice Lefu did not find them, at least to put the final nail on the coffin, because when he just throws it out like this without finding them for wasting their legal time, I think he's very charitable to them, because they will not tell us that APP, as a political party in Nigeria, they don't have a legal advisor, even state or national, or those they are fraternizing with don't have legal advisors. So that is a mockery of application to the court. That's a wasting of judicial time. That's also a wastage of resources, though it might not be a waste for them, because we know that as things are in Rivers State, APP could have not on their own approached a court. They have been sponsored, and we know where the sponsorship is coming from. It's coming from the state government that has obviously shown their interest, because APP, having not been a household name in Rivers State, at least we know of Accord, we know of Labour Party. These are the political parties that also have big, deep pocket politicians behind them. But APP, as we know, apart from the time their secretariat was allegedly attacked and all that, we never had anything from them. So for them to have even had the infantry to go and challenge a suit, which they are not a party to. They don't even have a member in the House of Assembly. They don't even have a voice in the political landscape of Rivers State. And having known that, as I was saying, that even the Omotosho case has decided the whole hula baloo about who is the authentic Speaker of Rivers State House Assembly as it stands today. And again, the appeal court, having said that the lower courts have no jurisdiction in hearing the matter ab initio, would have told an average law student, I'm not saying that somebody that have been called to bar, would have known that this case is in nullity already. Either you start it from afresh. I could recall when Ojos Okalo got sentenced, and when he got on appeal, and they said that he should go back, that there was an infraction, and the infraction was not that the case was not judiciously had, or fair hearing was not given to Ojos Okalo, but the problem was that the judge that had the case was transferred, and another judge now took charge of it, making it there was a judicial collapse, a judicial process collapse, that they say that hence another judge has taken over. He should have reviewed the case and called on the witnesses, and that case took a long time. So now that Justice Omotosho gave a landmark judgment, and the Okojombo faction appealed another judgment by Peter Lefu, and appeal court now gave a resounding judgment that settled the whole thing and said the court where you went, a state high court, has no jurisdiction to hear a case concerning a state House of Assembly. Then it should tell any reasonable law student or a lawyer that any other effort will be in futility.
The court that the APP went to is the court of Justice Peter Lefu. That's a federal high court.
I know,
actually.
no,
it's not
yes.
a state high court.
No, I'm not talking about their own.
We are dealing with the judgment of Justice Peter Lefu, yes, in the APP suit against the Rivers State House of Assembly. Now, the question I asked you is, Do you see this bringing the whole political impasse to an end in Rivers State? Do you see that happening? Because APP had come out to say that they were going to challenge the outcome of the judgment. They were going to appeal the judgment. The question is, do you see that do you see peace returning within the political ecosystem in Rivers State? The second question is, now that this judgment has also come out, further affirming the judgment of Justice Omotosho, do you see the state governor working in line with the judgment of Justice Omotosho and of Justice Peter Alifo?
The first leg of your question, I don't think this will bring to an end the litigations or the impasse,
Right.
in Rivers State political ecosystem, because judgments in Nigeria, the governor is saddled with immunity. And in Nigeria, they choose which judgment to obey, even when the laws has clearly stated what it is. It's just few weeks ago we came out from the litigation and the impasse in Abia State House of Assembly, after someone went to appeal court, and the appeal court being the final arbiter of litigations concerning State House of Assemblies and the Federal House of Representatives and Senate, as the case may be, gave a judgment, ordered INEC to retrieve a certificate of return, and ordered INEC to reissue it to the person from PDP. And the Speaker of the House disobeyed swearing the member in, thereby denying his constituency a fair representation, until the civil society group started crying, and the case now went to the Court of Public Opinion, and finally they just few weeks ago admitted him. So in Nigeria, this is not the first time we are going to see a governor disobey the court ruling, because like I have always told you, Laurentia, there is no penalty, there is no biting effect for somebody who fails until our legal jurisprudence being tinkered and made people to face the punishment of disobeying court orders. We will not get it right, because we turn out judicial finality every time, if not this Supreme Court judgment on the financial autonomy of local governments now, that the federal government have taken it upon herself to make sure that it sees the light of the day, because the federal government is saddled with the responsibility of disbursing funds, and they can now withhold it. That is why you see some of the state governors now running helter-skelter. But if not, have you seen how many times that financial autonomy has gone through the Supreme Court and it was not obeyed? So if the case of Rivers State, we are still awaiting the judgment of the Supreme Court as it concerns this case, the governor can choose the one he's going to obey, unless if the federal government uses another means of chastising.
When you say, with respect to Rivers State issue between the executive and the legislature, when you say the governor can choose the House of Assembly to work with.
No, I'm not saying the House of Assembly to work with.
So what exactly is the governor going to choose to obey?
No, they choose to obey even if they are reinstated. Even if the Supreme Court now says that the authentic House of Assembly Speaker, which is Martin Samehule, should return to his office, and the governor should now send correspondence to him, because as we know, given what Appeal Court has done and the judgment of Justice Omotosho, Martin Samehule remains the authentic Speaker of Rivers State House Assembly.
When you say Supreme Court tells Honorable Martin Samehule, led House of Assembly, to return.
No, by affirming the judgment.
There is a judgment already
by the Supreme Court. Yes, no, that's what I'm saying now.
Hold on, there is a judgment already authenticating them. And when the Appeal Court, in its ruling, the Appeal Court said that with regards to the speakership of Right Honorable Martin Samehule, yes, it's not in contention.
No, it's not.
And then the judgment, the ruling if I may use that word, the ruling or the order that authenticated Okojumbo was made a nonsense of by the appeal court. So when you say returning them, they are already existing. Probably
we are saying
no, because it gives a wrong impression, like they are waiting for the appeal court to return them.
No, the Supreme Court
you could say that the Supreme Court. You could say the Supreme Court is not returning them. There is an appeal of the judgment of the appeal court to the Supreme Court. So everybody is awaiting the judgment of the Supreme Court. And do not forget, the appeal was based on jurisdiction.
Of the lower court that had it.
It's based on jurisdiction, and that's simple. The issue of Martin Samihule, the appeal court has said it's not in contention. Probably the Supreme Court will shed more light, in favor or against Martin Samihule. But as it stands, pending when the Supreme Court gives judgment, Martin Samihule
is the authentic Speaker of Rivers State Assembly.
Because the appeal court has also said that the judgment that authenticated Okojumbo, the court in the first place that gave the judgment does not have the jurisdiction to give the judgment. So as it stands, that's why I asked you, would the governor keep recognizing Okojumbo in face of all these judgments in favor of Martin Samihule?
Laurentia, you know why I'm using a layman's language to interpret this judgment. We are here, we are sentimental. And you know that this particular issue...
sentimental.
This particular issue...
No, hold on. Don't say we. Say I am sentimental. I bet you moved from that statement.
A larger chunk of the Nigerian society, Nigerian citizens, are very sentimental when it comes to issue that has to do with the law and the court of public opinion.
All right.
So that is where I'm coming from. Now, you see why I am carefully choosing my words is because of who majority of Nigerians are. Now, the Nigerians don't look at the letters or the handwritings of the law. They go with sentiment. As it stands now, you and I know that the Rivers citizens are divided according to those being sentimental and the few who are only looking at the letters of the law and what the laws are saying. That is why I'm telling you that majority of them, it will dawn on them when the Supreme Court makes the pronouncement. Because Nigerians are always good at waiting at even in the judgment of the Supreme Court or pronouncement of the Supreme Court, they will also pick holes. Right. But I'm trying to lay the foundation that the Supreme Court as the final arbiter, once they lay their voices on this particular adjudication of the appeal court, that will be the final nail. But what I'm saying about the governor choosing the people he wants to work with is this. In as much as it's against the letters of the law. But here we are in Nigeria. We are not foreigners. Look at what happened in Edo State. The reinstatement of Shaibu. Obaseki went ahead to, disobey the court order, because if you are sitting and there is no correspondence from the three arms of government that should work in harmony, it is a disobedience to the court order. And has the Supreme Court a way of chastising or penalizing those who don't adhere to their rulings? It's what I don't know. That's what I'm saying, that our judicial led-hand procedures need to be tinkered. We need to have a way of punishing impunity, and not only the court. Now we call you and said we are calling you for how do they say it, that for court, the disobedience of the court ruling, contempt of court. That's the only thing. Even after the contempt, I think it's only fine or maybe a pronouncement. But as a governor who is sitting with immunity, even if they pronounce that there is a contempt of court as perpetuated by a sitting governor, how will he be punished? How will he be brought to book? That's a $1 million question. That's my fear. That at the end of the day, unless the otherwise happens, as the Martin Samihule has been pointing out the infractions of the Mr. Governor in Rivers State, look at the other week, the governor unilaterally appointed members of a non-existent, non-backed body or a commission by the Rivers State Assembly law, as enshrined in the Constitution, that the Rivers State shall make a law for the governance and the work in harmony with the executive. The governor appointed, I can't remember the name of the commission he appointed, and they swore them in. And the representation of the budget, all the other infractions that they have been pointing out, unless if there is an impeachment on the governor and the federal hammer. Because what happened, like you saw what is happening in the local 323 local governments in Rivers State now, barricaded by the police. Unless if after this particular pronouncement that we are waiting from the Supreme Court, the Martin Samehule led assembly should call the governor to order by serving him another impeachment notice and impeaching the governor, and the federal government will now use the federal apparatus and make sure that the government house is barricaded.
Now, wait.